Good morning, everyone. I call this hearing to order and a quorum is present. Without objection, the chair is authorized to call a recess at any time. I want to welcome all of today's witnesses and the members of the committee to the Oversight Investigation Subcommittee hearing entitled Protecting Whistleblowers and Promoting Accountability. Is VA making progress? I know that the members are familiar with our virtual hearings, but just a few reminders before we begin today's hearing. If you're experiencing any connectivity issues, please make sure your staff contacts our designated technical support so we can resolve those issues as quickly as possible. And to ensure that members and participants can have robust engagement, please keep your cameras on and remain visible at all times during the duration unless you're experiencing technical issues. Today, we'll be using a virtual timer. I think we're familiar with that, but if you want to keep that in your focus, select grid view and focus view, move your mouse over the second thumbnail from the right, click on the white circle and select lock participant. When you're recognized, you will need to unmute your microphone and pause for just a couple of seconds before speaking. We want to make sure we capture all your words on the live stream. And if you wish to have a document inserted into the record, please ask for unanimous consent. Have your staff email the document over to veteransaffairs.hearings@mail.house.gov, and it will be uploaded to the committee document repository. Any questions about procedures? Well, hearing none, we will proceed. I now recognize myself for an opening statement. Whistleblowers play an essential role in safeguarding the federal government against waste, fraud, and abuse. Disclosures from whistleblowers have been vital for learning about mismanagement and misconduct at VA. For example, it was information from whistleblowers in 2014 that revealed to Congress and the public that thousands of veterans suffered because VA officials had buried data showing lengthy wait times for health care. This became a major scandal for VA, but it led to important and long overdue reform. Whistleblowers, as we know from that instance and so many others, play a key role in transparency and trust in the federal government, and they must be protected. During the last congressional session, this subcommittee held a series of hearings examining VA's Office of Accountability and Whistleblower Protection, from here on out known as OAWP. The subcommittee has had serious concerns about OAWP's performance, effectiveness, and conduct, and for good reason. A 2019 Office of Inspector General report found that OAWP was a failing organization, and we heard that the office not only failed to fulfill its responsibilities mandated by law, but that it frequently worked directly against its core mission to protect whistleblowers. A prime duty of VA's whistleblower office is to investigate whistleblower claims and then to recommend to the secretary any appropriate actions to protect those who are subjected to retaliation for disclosing wrongdoing. However, VA employees who contacted the office to report retaliation often waited for years as their investigations went nowhere and the protection they needed never came. Though throughout most of the last administration, OAWP recommended almost no actions to address cases of retaliation. And to be perfectly blunt, VA had wholly neglected its duty to whistleblowers for years and years. So where are we now? OAWP leadership and staff deserve credit for implementing the Inspector General's recommendations from 2019. Leadership hired needed staff, conducted training, and they've reduced the backlog of investigations. These are all good signs of improvement. However, what does this really mean for the whistleblowers themselves? My office continues to hear from employees who are confused and frustrated by OAWP's procedures and communications. I really look forward to hearing today from VA witnesses about specific steps that VA is taking to ensure all investigations are given the time and consideration that they deserve. But the frustration for whistleblowers doesn't stop with OAWP. Along with full committee chair Mark Takano, I wrote to Secretary McDonough about VA's failure to uphold negotiated settlement agreements with whistleblowers. After VA investigates an allegation and concludes that VA retaliated, typically the employee and the lawyers from the Office of General Counsel negotiate a signed agreement to make the employee whole. These settlements could include specific agreements to reinstate the employee's position, to reimburse lost wages, and to ensure that the whistleblower no longer will face retaliation. However, these settlement agreements are not consistently enforced. Too often, VA promises whistleblowers they remain unfulfilled. Whistleblowers are frustrated, and we see this continue for months as VA struggles to honor its agreements. We need commitments from VA that settlement agreements will be properly enforced. In addition to OAWP, We're going to hear from VA's Office of Inspector General, whose 2019 report was really instrumental to the improvements that OAWP has made over the last couple of years. I also look forward to hearing from the Independent Office of Special Counsel, whose investigations into disclosures and retaliations are essential to employees and whistleblowers across the federal government, not just at VA. We're also joined by important advocacy groups, all of whom testified 2 years ago. These organizations assist whistleblowers through the convoluted and confusing reporting procedures, and they have firsthand understanding about what changes are still needed. From my conversations with Ranking Member Mann, I know we're going to have a bipartisan approach to this issue, including 2 bills that we've introduced that are aimed at strengthening how VA handles whistleblower complaints. The bill I've introduced increases OAWP's authority and independence. The minority bill takes a different approach, but also seeks a more clear and effective process. And so that's one of the things I'm really most interested in coming out of this hearing with, a path forward on how we can make legislative changes that will help deliver on the mission of this important office. So with that, I want to recognize Ranking Member Mann for 5 minutes. I appreciate his commitment to this issue, and I'll turn it over to you for an opening statement.
Great. Can you hear me okay, Chairman Pappas?
Yes,
yeah,
we can.
Well, thank you, Chairman Pappas. Congratulations on the bipartisan legislation on behalf of veterans that passed the House floor yesterday. Look forward to more good things to come. I'm glad that we're together today, even if virtually, to discuss protecting whistleblowers and promoting accountability at VA. I hope to see you all in person soon. Accountability is vital for any healthy, high-performing organization. I think is also integral to our previous hearing topic. Without a culture of accountability, it would be impossible to stamp out discrimination. And we know when accountability slips at VA, it is the veteran who suffers. In 2017, the bipartisan VA Accountability and Whistleblowers Protection Act passed the House 368 to 55 and the Senate by a voice vote. It was an historic achievement. The law gave the Secretary new tools to hold the workforce accountable to all levels in order to improve services for our veterans. It also established the Office of Accountability and Whistleblower Protection, or OAWP. OAWP was given the explicit task to investigate and make disciplinary recommendations concerning senior executives and top managers. According to OAWP, the office has conducted 350 investigations and issued 99 recommendations over the last year. While this is significant improvement over the handful of recommendations made in 2019, it is still a far cry from what would be adequate considering the VA size. Despite these improvements, problems do remain. When OAWP makes a disciplinary recommendation, the proposing and deciding officials do not have to accept it. I learned of 2 recent instances where OAWP investigators felt they had an open and shut case, but VA leaders declined to act on the recommendation, citing other circumstances. This means one of 2 things. 1, either the OAWP recommendations were sound, but their poor reputation inside the agency leads VA officials to disregard their opinions, or 2, OAWP's investigations were flawed and the recommendations should not have been made. Both possibilities are troubling, and I'm struggling to see the value of OAWP's investigations and subsequent recommendations if they are flawed or dismissed by the VA leadership. This is a major reason why I put together draft legislation that would remove the investigative and recommendation responsibilities from OAWP. OAWP would refer cases of whistleblower disclosures and retaliation to the Office of Special Counsel, or OSC. OSC already has the authority to receive, manage, and investigate allegations of retaliation, and the office has an impressive reputation for impartiality and rigor. In fact, many VA whistleblowers already file disclosures and retaliation allegations with both OSC and OAWP, leading to duplication and decreased efficiency. Unfortunately, I do not believe OAWP can succeed under its current structure. No matter how many layers, how much money, or how many new authorities Congress may give it, the Assistant Secretary will still report to the Secretary and will never truly be independent. I want to be clear. I'm in no way disparaging the hard work of the folks at OAWP. They deserve an environment where they can concede, but something has to change. I believe my draft legislation is a sound concept, and that is where we should start. However, I'm under no illusions that is perfect. I look forward to working with the chairman and stakeholders to improve it, to accomplish our mutual goals in a bipartisan way. With the time remaining, I would also like to turn back to the Accountability and Whistleblower Protection Act. OAWP's jurisdiction only covers roughly 10% of the VA workforce. Unfortunately, we know that individuals in the other 90% are responsible for retaliation, discrimination, waste, fraud, and abuse as well. To uphold accountability at all levels of the workforce, the law gives the Secretary the ability to remove, demote, or suspend an employee if his or her performance or misconduct warrants such discipline. That was meant to be a scalpel, not an axe. It instituted a disciplinary tool subject to appeal, but not an endless appeal. I believe VA is a more effective organization today because of that. However, unelected bureaucrats have begun to unravel that bipartisan authority. Last year, an arbitrator ruled that VA violated the American Federation of Government Employees Master Collective Bargaining Agreement, and it must go back and bargain over the implementation of the law with the union. As a result of this ruling, VA recently announced that it was suspending the use of the law for removals, demotions, and suspensions of AFG employees while negotiations over its implementation continue. There are 284,567 AFGA employees at VA. This means around 70% of VA's workforce can no longer be held accountable using the authorities Congress provided 4 years ago. I have serious concerns about this decision. Exempting almost 3/4 of a workforce from swift accountability will surely not produce a better product for the veteran. And VA's inability to discipline or remove a disruptive or problematic employee quickly may also lead to harm for whistleblowers and employees who are experiencing retaliation, harassment, and discrimination from an employer. The bottom line is delivering high quality and timely health care and benefits for our veterans is paramount, and ensuring that employees have a safe, healthy, and accountable work environment will allow VA to deliver on that promise. I'm concerned that taking away an important tool to hold poor performers accountable will negatively impact its mission. I hope the department can give us quick answers on how how long these negotiations over implementing the law will take, so important tool can once again be used to improve delivery of care and benefits to veterans. Once again, Mr. Chairman, thank you for holding this important hearing, and I look forward to the discussion. I yield back.
Well, thank you, Ranking Member Mann. I see we are also joined by Full Committee Chair Mark Takano. I would like to turn it over to him for 5 minutes for opening comments. Chairman Takano.
Thank you, Chairman Pappas and Ranking Member Mann and the rest of the subcommittee for holding today's hearing on whistleblower protection at VA. Let me just say from the outset that I'm very pleased by the genuine and sincere bipartisan interest on this topic. And I cannot stress enough how important whistleblowers are to improving how the federal government operates and serves the American people. Over the past few years, whistleblowers have helped root out fraud, waste, and abuse that directly affected the ability of veterans to access timely and high-quality care. VA employees who have firsthand knowledge of the inner workings of the department are in the best position to bring wrongdoing to the attention of Congress and the public. VA is entrusted with providing the highest quality service possible to our nation's veterans, and the department must listen when its employees have the courage to speak up about wrongdoing. Further, VA must create a culture where employees are not discouraged or stifled by the threat of retaliation, such as the loss of their jobs or workplace harassment, for simply speaking up. In this committee's hearings over the last few years, we've heard from numerous whistleblowers as they have brought serious issues at VA to light. But unfortunately, we have also heard about the struggles and suffering they have endured after speaking out. Not even testifying before the House Committee on Veterans Affairs protects a whistleblower from further retaliation. Let me be clear, the last 4 years of the previous administration have not been kind to whistleblowers. We've had a secretary who did not respect whistleblowers and actively worked against those who reported wrongdoing at VA. For example, one whistleblower complaint that was picked up in the media described top VA leadership installing political appointees in OAWP to, quote unquote, protect the secretary. We also know of an incident where hospital staff pointed out wrongdoing in a surgical ward that was placing veterans at risk. Rather than taking the whistleblower seriously, VA put out a press release belittling the whistleblower. We also heard from the Inspector General that the Office of Accountability and Whistleblower Protection, only established in 2017, was failing at its core objective. Most bizarrely, we had multiple reports of whistleblower retaliation against employees who work within OAWP, the very office that was created to protect whistleblowers from retaliation. Now, 2 years ago, I said that I did not have confidence in OAWP and could not in good conscience recommend a whistleblower to seek protection from the office. I recognize that VA has reported improvements during the past year, including reducing its backlog of investigative cases and implementing most of the 2019 Inspector General's 22 recommendations. Yet, many whistleblowers continue to struggle, with VA dragging its feet for months and months before agreeing to make the whistleblower whole after suffering retaliation. The current situation is a merry-go-round of frustration. VA whistleblowers are forced to blow the whistle again about how VA treats whistleblowers even after confirmed findings of retaliation. Now, I joined Chairman Pappas in sending a letter in March to Secretary McDonough about the need to ensure that VA follows through on its promises to whistleblowers. I look forward to a productive exchange with the new General Counsel and soon about how best to fix the situation. But whistleblowers should not need a joint letter from congressional leaders to receive the attention they deserve. Trust is hard to build and easy to lose. And VA has lost a lot of trust building to do after the last 4 years. And I am still waiting to see whether OAWP is successful in developing a reputation among veterans and whistleblowers as a trusted and effective ally. We have new leadership from President Biden and Secretary McDonough who have voiced strong support for real cultural change within the department. We also have a nominee for Assistant Secretary to run OAWP. And I have high expectations for VA to demonstrate that the Office of Accountability and Whistleblower Protection can live up to its name. Only then will I feel comfortable sending a whistleblower to that office. I look forward to hearing from all the witnesses on what improvements they have seen for whistleblowers at VA and what changes are still needed. Mr. Chairman, I yield back.
Thank you very much, Chairman Takano. We will now turn to our first panel. And I want to start by recognizing our first witness. We have from VA, Mr. Hansel Cordero. He's the Acting Assistant Secretary of the Office of Accountability and Whistleblower Protection. Mr. Cordero, you have 5 minutes.
Thank you, Chairman Pappas. Chairman Pappas, Ranking Member Mann, and members of the subcommittee, thank you for inviting me to testify at this hearing on whistleblower rights and protections at the Department of Veterans Affairs. I'm honored to join this distinguished panel. Whistleblower rights and protections are a cornerstone of improved accountability at VA. I know the courage required to blow the whistle on wrongdoing. I also understand the impact that whistleblowing often has on the individual who raises concerns. I joined VA's Office of Accountability and Whistleblower Protection in 2019 to improve accountability and whistleblower rights. Improving accountability involves 2 key areas: personnel accountability through investigations and education, and organizational accountability to ensure that systemic deficiencies are identified and addressed. OAWP provides whistleblowers and others with the courage to speak truth to power a channel to safely raise concerns of wrongdoing. When an individual alleges retaliation for raising concerns about wrongdoing at VA, OAWP investigates these allegations. OAWP also investigates allegations of VA senior leader misconduct and poor performance. Senior leaders include political appointees, senior executives, facility directors, associate directors, chiefs of staff, and nurse executives. Because OAWP is not a component of any VA administration or staff office, we are able to investigate these allegations in a fair and unbiased manner. OAWP investigators receive comprehensive training developed by experienced supervisors. Investigative work products undergo several levels of supervisory review and follow investigative standards established by the Council of Inspector General on Integrity and Efficiency. OAWP also has a quality division that reviews our investigative work product for quality assurance. If OAWP substantiates allegations, it makes recommendations to VA for disciplinary action against a wrongdoer and corrective action for the whistleblower. OAWP has made significant progress as an organization. Our accomplishments, covered in more detail in my written testimony, resulted in the closure of the last of 17 OAWP-related recommendations in the Office of Inspector General's October 2019 report. Highlights of some of our accomplishments include, during the last year, OAWP issued more than 99 recommendations, including 40 disciplinary recommendations for senior leader misconduct, an additional 29 disciplinary recommendations against supervisors for whistleblower retaliation, and another 30 non-disciplinary recommendations, for example, corrective action for whistleblowers. While continuing to investigate new allegations, OAWP also resolved all backlogged cases, many which dated back to 2017 and 2018. My written testimony provides examples of some of our investigative work. OAWP trained more than 352,000 VA employees about whistleblower rights and protections. In addition, we trained more than 34,000 supervisors about ways to encourage employees to disclose wrongdoing in an attempt to create a culture that values, rather than fears, whistleblowing. OAWP implemented a portal that allows individuals to submit whistleblower disclosures and complaints securely and confidentially using any web-enabled device, including cell phones. Once allegations are received through the portal, it is immediately assigned for review within OAWP. With regard to organizational accountability, OAWP implemented a program to track and confirm the compliance of recommendations made by external oversight entities. We have tested VA's continued compliance with several Office of Inspector General and Government Accountability Office recommendations. The results of those tests and our recommendations on corrective action are designed to address the root causes of systemic issues in VA. OAWP works closely with other oversight entities, including the Office of Inspector General and the Office of Special Counsel, to mitigate duplication of investigative efforts. We meet monthly with leaders from these offices to ensure that we continue to expeditiously investigate allegations of wrongdoing. We worked with these offices to develop whistleblower rights and protections training. We also worked with these offices to develop a chart available on our website that identifies differences between each office and what we investigate. Stakeholder feedback is critical to assessing OAWP's progress. OAWP leadership met with stakeholders, including labor partners and good government groups, including those on the next panel. We solicited input from these groups and will continue to seek feedback as we improve. We also continue to work closely with congressional staff on legislative proposals to strengthen whistleblower rights and protections and to continue to promote and improve accountability within VA. Mr. Chairman, Ranking Member Mann, members of the subcommittee, this concludes my statement. Thank you for the opportunity to testify before the subcommittee. I will be happy to hear your feedback and respond to any questions that you may have.
Thank you, Mr. Cordero, and I appreciate that overview. We will turn to our next witness. It's Mr. Christopher Wilbur, Counselor to the Inspector General at the Office of Inspector General of the Department of Veterans Affairs. Mr. Wilbur, you're recognized for 5 minutes.
Chairman Pappas, Ranking Member Mann, Chairman Takano, and members of the subcommittee. Thank you for the opportunity to discuss our efforts to protect whistleblowers while examining their underlying complaints and concerns. I'm happy to also provide an update on our 2019 report, Failures Implementing Aspects of the VA Accountability and Whistleblower Protection Act of 2017. The report found significant failings at the OAWP, which had a chilling effect on complainants that to some extent lingers today. Before I begin, I want to express my condolences to the families and loved ones of the veterans who were murdered at the Clarksburg VA Medical Center by Rita Mays. Last month, I had the opportunity to testify to this subcommittee in support of Representatives Rice and Radewagen's H.R. 2428, the Strengthening Oversight for Veterans Act, which would provide the VA OIG with testimonial subpoena authority. During our healthcare inspection of the care and oversight deficiencies at Clarksburg, we became aware that the facility's risk manager did not perform in-depth mortality reviews as required by VHA policy. Unfortunately, the risk manager was no longer a VA employee at the time of our inspection and refused to speak with our staff. We had no way to compel the individual's cooperation to understand better the reasons why mortality reviews were not done at the facility. Testimonial subpoena authority would have been a crucial tool to help us get further information on the serious and pervasive clinical and administrative failures that we identified in virtually all critical patient safety functions at Clarksburg. Mr. Chairman, in October 2019, we published our review focusing on the OAWP's operations from June 2017 through August 2019 and found significant deficiencies. We made 6 overall findings. First, that the OAWP misinterpreted its statutory mandate, resulting in failures to act within its investigative authority. Second, that the OAWP did not consistently conduct procedurally sound, accurate, thorough, and unbiased investigations and related activities. Third, the office struggled with implementing the Act's enhanced authority to hold executives covered by the Act accountable. Fourth, the OAWP failed to fully protect whistleblowers from retaliation. Fifth, VA failed to implement various requirements under the Act, including revising supervisors' performance plans and developing supervisors' training regarding whistleblowers' rights. And finally, the OAWP lacked transparency in its information management practices. We noted that OAWP's early leaders made avoidable mistakes in the development of the office that created a culture that was sometimes alienating to the very individuals it was meant to protect. We made 22 recommendations across those findings. Today, only one recommendation remains open, that the Office of General Counsel determine whether VA policy documents regarding administrative investigations should be revised to clarify whether they apply to the OAWP. Since our report was published in 2019, the OIG has observed advances in the OAWP's operations under former Assistant Secretary Bonsanto and under Mr. Cordero. There is also marked improvement in relations between our offices. OIG and OAWP leaders meet regularly to discuss matters of mutual interest and updates on the OAWP's progress in developing its procedures and addressing our 2019 report recommendations. The OIG continues our focus on ensuring that the Act is implemented appropriately and that its goals are achieved effectively. We believe that prompt, accurate, and thorough investigations by the OAWP and VA leaders generally are critical to promoting accountability at VA and rebuilding the trust of whistleblowers. I want to conclude by thanking those whistleblowers and others who contact us with information on fraud and other crimes, waste, and abuse that could negatively affect veterans, their families, or VA's ability to make the best use of taxpayer dollars to provide high-quality services and benefits. OIG staff will continue to work to protect their confidentiality. It was a whistleblower, a concerned employee in Fayetteville, Arkansas, who selflessly alerted OIG staff to their concerns about a pathologist, Robert Levy, who was providing patient care while impaired. An extensive review of medical records identified the incorrect diagnoses he made while impaired, leading to a 20-year sentence for mail fraud and involuntary manslaughter. While we cannot bring back those who suffered because of his crimes, that whistleblower may have saved untold other lives. Chairman Pappas, this concludes my statement. I would be happy to answer any questions you or other members of the subcommittee may have.
Thank you, Mr. Wilbur. Our next witness is Ms. Elizabeth McMurray, the Director of the Retaliation and Disclosure Unit at the Office of Special Counsel. Ms. McMurray, you have 5 minutes.
Good morning, Chair Pappas, Ranking Member Mann, esteemed members of the subcommittee, and fellow panelists. Thank you for holding this important hearing. I'm honored to be here today. The U.S. Office of Special Counsel is strongly committed to supporting veterans and to helping the U.S. Department of Veteran Affairs create a positive workplace environment for its employees. Ensuring that VA whistleblowers have a voice enables the VA to best protect the health and safety of our veterans. Special Counsel Kerner, as part of his fierce advocacy for whistleblower protection, has made working with the VA a top priority during his tenure at OSC. He has met individually with each VA secretary during his term, including, most recently, with Secretary McDonough. He met as well with the former head of the Office of Accountability and Whistleblower Protection, Dr. Bonsanto, and with VA Inspector General Michael Missel. During these productive conversations, the Special Counsel emphasized the need for VA leaders to send a clear message from the top about the importance of whistleblowers and to affirm their strong commitment to prevent and address whistleblower retaliation. As you know, whistleblowers serve a crucial function in government by shining a light on wrongdoing. The statutes governing OSC's work make our agency a critical resource for whistleblowers in 3 main ways. First, we provide whistleblowers with a safe channel to make disclosures of wrongdoing, and we ensure that those disclosures are properly addressed. In particular, we have the authority to order an agency to conduct an investigation into any disclosure that warrants one, and our statute provides the whistleblower a special role in reviewing and commenting on any responsive agency report before the Special Counsel makes a public determination on the reasonableness and sufficiency of the agency's investigation and findings. Second, we provide an avenue for whistleblowers to seek redress for retaliation and other prohibited personnel practices. Here, unlike with disclosures, OSC has the investigative authority to conduct its own investigations. We also have a very effective mediation program through which we resolve many prohibited personnel practice complaints. Additionally, OSC has the enforcement authority to pursue corrective action for individual complainants, as well as disciplinary and systemic action where appropriate. The combination serves to send a strong message, not only to the individual whistleblower, but to the rest of the workforce as well, which is important because whistleblowers come forward primarily when they have confidence in the process and when they do not fear retaliation. The final piece of OSC's three-pronged approach to assisting whistleblowers consists of our robust outreach and training program, whereby we train managers and employees at federal agencies on all facets of OSC's mission. During Special Counsel Kerner's tenure, OSC has provided numerous trainings for the VA and OAWP specifically. In addition, OSC has regular monthly meetings with representatives from the VA's Office of General Counsel, OAWP, and the VA Office of Medical Inspector. Developing a good working relationship with the VA through open lines of communication has been critical to working towards our shared goal of promoting better government through transparency and accountability. We remain steadfast in our commitment to helping the VA, this committee, and this subcommittee in particular, provide the best service that it can to veterans by ensuring that any reported wrongdoing receives appropriate consideration. I know that our Deputy Special Counsel for Legislative Affairs works with your staff regularly and facilitates OSC's support for your important work. We thank you for sharing with OSC the draft legislation the subcommittee is currently considering. We have had the opportunity to review the proposals and look forward to continuing to work with you and your staff as you consider these and other ideas. I'm happy to answer any questions you may have, but wanted to emphasize up front how vital it is for OSC to maintain its independence. OSC's success is largely determined by the trust placed in us by the federal workforce. For this trust to continue, federal employees must remain confident that OSC remains above reproach when it comes to our work and our independence. In closing, VA employees are among the greatest patriots in federal service, as they have devoted their professional lives to serving veterans, and of course, many are veterans themselves. It is imperative that they feel supported in doing their jobs without fear of reprisal. OSC works hard every day to make that goal a reality. Thank you again for holding this important hearing. I look forward to answering any questions you may have.
Thank you very much, Ms. McMurray, for your comments. I appreciate that and the work that you do. We will now turn to the questioning portion of today's hearing, and I'll begin by recognizing myself for 5 minutes. Clearly, a key measure of success for VA's work with whistleblowers is whether investigations conducted by OAWP result in recommendations to the Secretary for action. So, Mr. Cordero, I'm wondering if I can start with you. And I know you talked about this in your opening. Can you remind us how many recommendations for actions OAWP has made in the past year?
We have made 99 recommendations for action from April 2020 to April 2021.
And so of those 99, how many involved cases of retaliation?
Probably about 26 or so involved.
So we've got, okay. So we've got 26 of 99 that were in response to retaliation investigations?
That's correct. I'm sorry. Let me revise. I think it's 29. Sorry.
Okay. So the overall number of completed investigations and recommendations to the Secretary has clearly grown over the last year. We are pleased with that number, but considering that the large number of VA whistleblower cases that come to the office every year, it still seems pretty low. So of all the recommendations for discipline that OAWP submits to the Secretary, how many of those were acted upon?
So approximately over half have been implemented by the department. And then we are testing several others, and then less than that have been non-implemented. So over half have been implemented by the department.
So you've got recommendations where half you feel confident about the implementation of those recommendations, but half, roughly speaking, these are recommendations for discipline are not implemented. To me, that seems like a lot of recommendations where OAWP's work is not acted on. So who at VA oversees enforcement of these recommendations for discipline, and what's OAWP's role moving forward?
So within OAWP, we have a system where we track the reasons why recommendations are implemented or not implemented. And so again, we can't enforce our recommendations. So all we can do is basically make a recommendation. We provide the evidence file supporting it. And then a proposing official decides whether they want to take OAWP's recommendation or not. When recommendations are not taken, we identify why they weren't taken. We are looking to identify trends to see if we can, through our analysis of the reasons why recommendations were not taken, identify trends, and if appropriate, we would make recommendations to the Secretary on improving the approval process for those recommendations.
Are there any trends that you're seeing that you can discuss today, or is the data not complete enough?
So, I mean, a common trend that we're seeing sometimes, for example, is a proposing official who agrees with OAWP's recommendation. They propose the action recommended by OAWP, and a deciding official who hears the employee's response decides otherwise. That is something that we've seen in some cases. In other cases, typically, you may have an instance where an individual where they have where we found through clear and convincing evidence that the department could not overcome and show that whistleblower retaliation would not have occurred, and we find for whistleblower retaliation, in some instances, we find that proposing officials disagree with that, and they will say, well, while OAWP found that, we disagree, and we feel clear and convincing evidence would show otherwise. So there are some in which they disagree with our analysis. They agree that the person was a whistleblower, but they believe that they can overcome that burden, that heightened burden. But in other cases, it's just simply a fact that deciding officials, after hearing the employee's reply, disagree with the proposing official and OAWP's underlying recommendation that the proposing official agreed with at one point.
Well, I find that fact deeply concerning that half the time these recommendations aren't implemented, that it appears that officials are basically ignoring the recommendations and the work that you have done, which I think is really important ultimately to the delivery of care and the support for our veterans. So I think that's an issue we've got to talk a little bit more about. But let's talk about when there is a case where an investigation finds that retaliation has occurred, whether that retaliation is determined by OSC or OAWP, the whistleblower should be made whole. And this could include reinstating the whistleblower's employment and steps to prevent further retaliation. Mr. Cordero, I understand that even with a recommendation by OAWP to help a whistleblower, the details aren't ironed out by your office. At that point, the Office of General Counsel steps in to negotiate a settlement agreement with the whistleblower. Chairman Takano and I have deep concern about this issue. We sent a letter to the Secretary after learning that many whistleblowers were not seeing their settlement agreements with VA enforced. Months can go by with no action. I understand the Office of General Counsel typically negotiates the department's settlement agreements. And Mr. Cordero, I'm wondering, does OAWP play a role in tracking settlement agreements between individuals in the department to ensure that VA is following through on its promises?
So I think, again, we appreciate the concerns that the committee staff has raised to us about how VA tracks and confirms settlement agreements. We received the letter from you and Chairman Takano about these settlement agreements. We take the concern seriously. Within VA, we're deliberating a way forward for VA to track and confirm VA's compliance with these settlement agreements involving whistleblower retaliation. The short answer is OAWP doesn't track those at this time. But again, we are deliberating a way forward, and we appreciate those concerns, that are raised to the department about the tracking and confirmation.
Well, thanks for that. My time is up here, but it clearly sounds like there's not a strong mechanism for the department to ensure that whistleblowers are made whole. I think it's a concerning issue, so hopefully we can talk more about it. With that, I'd like to turn things over to Ranking Member Mann for 5 minutes of questioning.
Great. Well, thank you, Mr. Chairman. I also have some questions for Mr. Cordero, kind of in line with what Chairman Pappas was just asking, I guess specifically, Mr. Cordero. Over the last year, OAWP issued 69 disciplinary recommendations. How many of these 69 have not been accepted by the VA?
I would probably say, again, like I said, under half have not been accepted. So I can give you an exact number later on, but that's our number.
I would like an exact number. Is that something you could get to me by the end of the week?
Yes, we could get that.
Okay, we can follow up with you on that. Do you believe that any VA employee can be a whistleblower and any supervisor at any level can be a retaliator?
That's correct. I think any employee can be a whistleblower and any supervisor at any level can be a retaliator. And again, we investigate retaliation allegations against any VA supervisor. So that's every VA supervisor included within our investigative scope.
Okay. Yeah. I also believe accountability and respect for whistleblowers must be guaranteed at every level of an organization. I think it's a serious mistake to undermine the disciplinary procedures of the accountability of Whistleblower Protection Act for the majority of the VA workforce and pretend only a few thousand senior leaders are capable of really retaliation. Any comments or any reaction to that?
So again, we not only investigate senior leaders, we investigate every VA supervisor where there's an allegation of whistleblower retaliation. So that would be any VA supervisor that would fall under investigative scope for whistleblower retaliation. So we investigate more than just, I think there are about approximately 40,000 VA supervisors, and those would all fall under our investigative scope if there's an allegation of whistleblower retaliation made against one of the supervisors.
Okay. How often have you advised the secretary on the issues of accountability since sworn in February?
I meet monthly with the secretary, and we talk about some of the types of trends that we're seeing. We talk about upcoming issues, and we talk about matters raised, whether through feedback that we receive or through comments and concerns that whistleblowers are raising to us. So the secretary is able to see some of the trends and patterns.
Okay. If you could change anything or one thing about OAWP's statutory mission, what would it be and why? Or if you were going to improve it, how would you go about doing that?
So, I mean, respectfully, I think we've received both the legislative proposals. We are happy to continue working with the committee to provide technical advice on these proposals. We respectfully defer views on those bills. And so I don't take a position. I can't take a position on either of those bills there.
Okay. Okay. My next questions are for Ms. McMurray. Sorry. I know a large percentage of your office's whistleblower retaliation claims come from the VA. Can you tell me in a typical year approximately how many of those alleged retaliations by a senior executive and how many concern retaliation by a lower level employee?
So that's a really good question. We can definitely put that information together for you. I don't have that off the top of my head. I can tell you about a third of our cases are from the VA at this point.
So a third of your cases are from the VA, and you could give for me the kind of the breakdown of senior versus non-senior. That would be possible.
We can absolutely work with your staff to put that together. Yes.
Okay. We'll follow up with you on that. And ultimately, if we did transfer the investigative functions of OAWP to OSC, do you believe that your agency could do that work?
So currently, any VA employee who wishes to file with OSC can. As you know, I indicated, because such a large number of VA employees currently file with us, we don't have any reason to believe that VA employees don't know at this point about OSC. In fact, VA has done a very good job of letting their employees know that OSC exists. I don't know how much additional work it would be for us, given the number of dual filers and the number of VA employees who currently file with us. It really would be hard for us to say how many additional cases we would be getting in that circumstance.
Okay. Thank you. That's all my questions, Mr. Chairman. I yield back. Thank you.
Thank you, Ranking Member Mann. I'll turn things over to Chairman Takano for 5 minutes.
Thank you, Chairman Pappas. Mr. Cordero, we all agree that OAWP needs to build trust with employees and whistleblowers. How is OAWP rebuilding trust with the whistleblowers?
I appreciate that question. One of the key things that we've done is start engaging with stakeholders. One of the steps we've done here, for example, is our staff regularly communicate with whistleblowers about the status of their matters. We've obviously resolved a lot of backlogged cases. So these are cases where from 2017 and 2018, OAWP may not have contacted those whistleblowers at that time. And in resolving those cases, we did reach out to the whistleblowers to talk to them. Generally, we reach out to whistleblowers within 1 to 2 business days of their submission to OAWP. We conduct clarification interviews to ensure that we understand the issues before we investigate. We also have updated our website to include the web-based disclosure form that I mentioned. We've also interacted and met with several individuals on the next panel and good government groups to understand, some of their sort of thoughts on what we can do to improve and to take their feedback and actually incorporate that as we continue to improve as an organization.
One of the things I recall is that I recall some of my staff just reporting to me that the number of complaints were not credibly there was the number of complaints weren't credible. In other words, there was an extraordinarily low number of complaints being registered by whistleblowers. Does that comport with what you know?
No, I think we're seeing, at least in my mind, a growth in the number of complaints filed with OAWP. I think as people understand a little bit more about what we do and can understand a little bit, and my written testimony provides some great case examples of the work that this office has done. I think you could see an impact. Corrective action we have recommended that has been taken. I
meant to say, Mr. Cordero, when the office was having its troubles, that there were a low number of complaints, but you're seeing a rising number of whistleblower complaints now, and that might be a measure of the increased trust in the office among employees.
That's what I believe. Again, I think employees have a right to file, and they often do file with OSC and OAWP simultaneously. We work closely to avoid the duplication of efforts, but when they do file with OAWP, we simultaneously will look at the issue, and we work with OSC to mitigate a duplication of efforts. So we may look at senior leader misconduct, or we may look at one part of the allegation, OSC may look at another. But we've taken these steps and efforts to show effectively our seriousness. Each allegation we receive is reviewed in thoroughness and in its entirety and taken very seriously.
Now to another question. In 2019, Dr. Catherine Mitchell testified before the subcommittee, and our staff has stayed in contact with her. Shockingly, despite having a signed settlement agreement in hand, she is still facing issues with her situation. A large part of her frustration is that it is still unclear who is in charge of her case and who is responsible for resolving even basic administrative steps regarding her position. Mr. Cordero, what role could OAWP play in ensuring whistleblowers like Dr. Mitchell are made whole in a timely manner?
So I think we actually play a critical role at the outset, again, offering a forum for individuals to file complaints. We also hold disciplinary actions taken under 38 U.S. 714, which is an Accountability Act measure, if a whistleblower has a disclosure with OAWP or OSC. With regard to settlement agreements, as I mentioned earlier, we are deliberating within the department on ways in which we can improve how we track and confirm implementation and OAWP's role in that process.
Well, tell me a little bit about those discussions. What my question was, what role could they play? So, I mean, you're having discussions. What is it that you think? What ideas are being batted around?
So, for example, under the Equal Employment Opportunity, if there's an EEO settlement agreement, Equal Employment Opportunity Settlement Agreement, the Office of Resolution Diversity, Office of Resolution Management, Diversity and Inclusion actually tracks and confirms those settlement agreements centrally within the department. So I think the discussion is whether OAWP should have that function, and if so, how it would perform the function in conjunction with the settlement authorities and with the Office of General Counsel that advises those settlement authorities.
Mr. Chairman, I yield back.
Thank you, Chairman Takano. I will now recognize Ms. Radewagen for 5 minutes.
Thank you, Chairman Pappas and Ranking Member Mann, for holding this hearing today. And thank you to Chairman Takano as well. Thank you to the panel for your testimony. Welcome. Ms. McMurray, what percentage of VA cases your agency reviews are duplicative of cases filed at OAWP as well? And what advantages do whistleblowers have by filing with OSC versus OAWP?
Thank you very much for your question. OSC does not have the data to answer the first part of your question. So we only know which cases are filed with us. We do not have a way of tracking, nor do we sort of collect information about whether or not VA employees have also filed with OAWP. So that would probably be a better question for OAWP if they track that information. With respect to the second part of your question, OSC believes very strongly in whistleblower choice, and we believe very strongly that whistleblowers should have as many options as possible within reason. And we believe that whistleblowers should choose to come to OSC. When they choose to come to OSC, what they are getting is an independent agency looking at their allegations. And on the prohibited personnel practice side, they're getting enforcement authority. So if OSC makes a determination that a prohibited personnel practice has occurred, like whistleblower retaliation, OSC has the enforcement authority to seek individual corrective action as well as disciplinary action from the agency. If the agency does not agree, we can go to the Merit Systems Protection Board to seek enforcement.
Mr. Cordero, do you believe accountability and whistleblower protection are integral principles? In other words, one cannot operate effectively without the other?
That's correct.
Thank you. Mr. Wilbur, I think I have just a little bit of time left. And Ms. McMurray, what is your view of how whistleblowers view OAWP? Do you believe that OAWP's work can ever have been seen, or how do you say this, as truly independent?
Well, I don't think that they will be seen as truly independent, because in fact they are not. That is one difference between OSC and OIG versus OAWP. I do think since our report came out in 2019, we have seen fewer complaints coming through our hotline about how OAWP has handled people's complaints and how it has handled whistleblowers. And so, I think we view that as seeing an improvement. They've implemented the recommendations from our report, and we believe the office is improving in how it relates with whistleblowers based on the evidence that we've seen.
Thank you, Mr. Chairman. Yield back.
Thank you very much, Ms. Radowagon. I'll now recognize Mr. Lamb for 5 minutes.
Thank you, Mr. Chairman. Ms. McMurray, did I hear it right that you said a third of all your cases come from the VA?
So on the disclosure side of our shop, as well as the prohibited personnel practice side, approximately 1/3 do come from the VA. That's correct.
And has that been the case for a long period of time, or is that level a more recent phenomenon?
No, that's been the case for a while. We could certainly go back and provide you with the statistics, but that's not a new percentage for us.
Do you have any opinion as to why that is? Is it driven simply by the size of VA and the number of employees, or is there more to that story? It just seems like a lot given everything that's under your jurisdiction.
Right. So that's an excellent question. Unfortunately, we don't know exactly why that is. The VA obviously is enormous. So it's one of the largest agencies that we have jurisdiction over. So that certainly is part of it. As I mentioned earlier, the VA has also, from OSC's perspective, done a very good job of letting their employees know that we exist. So there are many federal executive branch employees out there at other agencies who are not as familiar as with OSC as VA employees are. So that could be another reason. But we would really be speculating as to what the reason for the high number of filings is.
Thank you for that. And Mr. Cordero, I think this question is best for you. What is the exact communication that the VA, whether it's your office or another one, gives to your average employee about OSC? Like, according to Ms. McMurray, it's successful. They know it exists. But what is it that you actually tell them about OSC versus OAWP and the options that an average worker has?
So I think that it's a great question. It's one of the things that we focus on in OAWP is training and educating employees about their rights to file. And like I said before, they can go to OSC, they can go to OAWP, and they can go to the Inspector General's office. So we do.
I think what I'm asking is, are those treated as basically equal options in the eyes of the average worker?
Correct. They can go to these offices. New employees, when they come on board in VA, receive training. We have OSC's information on our website. We have a what's the difference chart that shows the differences between the three of our offices, also available on our website. And so employees can clearly see where they can file, and they can decide what they would like to do and where they would like to file their complaint.
And do you? I know Ms. McMurray mentioned earlier that she didn't have the data available to know how many employees file in both places, but do you know that?
I think we have started collecting some of that data. I can go and we can check and look into that and get back to you if you don't mind.
Yeah, I think it would be helpful. It doesn't have to be right away, but it would be helpful to know if a lot more employees are filing at OSC than within the VA. Obviously, that's one indicator of where the trust is. And I think that would help us as far as assigning responsibilities and resources going forward, knowing what the workers already seem to trust and like using. So with that, Mr. Chairman, I yield back. Thank you.
Thank you. And thank you for those questions. I think that data would be really important to understand how to move forward. And if you can provide us some data over time as well, so we can see how things have changed, I think that is important to see the full picture. So thank you for that. With that, I'll turn things over to Ms. Luria for 5 minutes.
Well, thank you, Mr. Chairman and Ranking Member Mann. Mr. Cordero, did I understand that the Office of Accountability and Whistleblower Protection made almost 100 recommendations to the Secretary during the last year? However, the VA has only implemented half of the recommendations for action, such as protecting whistleblowers. What is being done about the other half?
So that's correct. We've made 99 recommendations from April to April. VA implemented over half of those recommendations. For the disciplinary recommendations that are not implemented, by law, VA has to notify Congress and basically with the explanation as to why those recommendations were not taken. So there's a letter that the Secretary sends out to the chairs of the respective House and Senate sides explaining why a recommendation was not taken. And that's typically the process that happens when a recommendation is not taken. Again, I think one of the critical things here is we have started tracking and are looking for trends to better advise the Secretary on changes that may be appropriate to that recommendation approval process. Right now, that approval process for recommendations, a recommendation is usually made to the supervisor of the senior leader or the supervisor of the supervisor found to have committed retaliation. So it's at a level that's a direct connection level. And we are looking for trends to see if we're seeing patterns so we can better advise the Secretary.
Okay, so have you captured any data? How many of these recommendations to the Secretary dealt directly with addressing cases of retaliation against whistleblowers? And of those, how many of those recommendations have been implemented?
Like I said, so 29 recommendations out of the out of the 99 recommendations, 69 involved disciplinary actions. 29 of those involved discipline against supervisors for whistleblower retaliation. We also have another 30 non-disciplinary recommendations. So typically when we recommend disciplinary action for supervisor, we would also recommend corrective action for the whistleblower, that is put the whistleblower back into their position. And we track those recommendations, whether the facility has implemented them or not. I don't have off the cuff effectively an answer as to what percentage of those 29 and 30 recommendations that I mentioned have been taken, the number exactly, but like I said, over half have been taken. So it would probably be about half of those, over half of those that have been implemented.
Okay, well, thank you. And we would love for you to continue to follow up with us and update us with that information. Mr. Wilbur, would you agree with the actions the VA took to follow your recommendations, specifically recommendation 5 to adopt a standard operating procedure and detailed guidance to make certain they are fair, unbiased, thorough, and objective in their work?
Yes. So in following up our report and our recommendations, we got action plans from OAWP. Initially, in some instances, those action plans weren't necessarily what we would have expected, but through dialogue with OAWP, we got updated action plans. As you say, they implemented their procedures in 0500. We reviewed that and found it adequate. We don't comment on the sort of the overall quality or the decisions they've made, provided those decisions are reasonable. And so we were comfortable closing out those recommendations based on the action plans and the implementations of policies that we saw from OAWP.
Okay, thank you. And thank you to all of our witnesses today. And Mr. Chairman, I yield back the remainder of my time.
Thank you very much. I think we'll do another round with this panel, and maybe I could turn it to Ms. McMurray. Appreciated your comments, and I know you had some back and forth with a couple of the members on the number of VA cases that you handle. Do you have information that could help us get an apples to apples comparison of how many recommendations you make to VA and how many of those are acted upon?
So I think this is information that we could probably follow up with afterwards to get you some numbers. Typically, through our process, once we have completed our investigation, if we come to the conclusion that a prohibited personnel practice has occurred, before we use our enforcement authority to go to the board, we typically will ask the agency to take appropriate corrective action and or disciplinary action. And if they do not take the action that we think they should take, at that point, we could go to the board. We have very few cases that wind up with us having to go to the board. So if that gives you any indication, typically we are able to get the agency to take the action that we need to take. But again, we can follow up with specific numbers after the hearing.
Okay, I think that would be helpful because what we've heard from OAWP, the figure about half are not implemented. I think it would be important to know how you do that. And can you just remind us again about, the enforcement mechanisms that you have when you make recommendations? Sure, absolutely. So when we make a determination that a prohibited personnel practice has occurred, that triggers an automatic proposed discipline that the agency needs to make. And so there's that piece of it, but the proposal alone is insufficient for OSC's purposes. We have the ability to review and approve discipline. And if the final recommendation is not not appropriate from our perspective, we will not approve that discipline. And we could then at that point go to the Merit Systems Protection Board to seek discipline through litigation. On the corrective action side, again, once we make a determination, we will ask the agency to take appropriate individual and systemic, sometimes corrective action. If the agency does not agree to take the action that we think is appropriate, again, we can litigate that through the Merit Systems Protection Board and seek enforcement that way. Okay, thanks for you making that clear and charting that path for us. Now one of the bills that we've got under consideration would transfer OAWP's investigative authority to OSC. I'm wondering if you could discuss what that would mean for OSC in your work. So as I mentioned earlier, VA employees currently can come to OSC directly and bring their complaints directly to OSC. As far as how much overlap there is between the individuals right now who go solely to OAWP and don't come to OSC, we don't have that data, so I couldn't estimate how many more cases would be coming to us. But again, I would emphasize that right now, VA employees can come to OSC. So this legislation doesn't give them the additional choice of going to OSC because that choice, or the proposed legislation, that choice already exists. Well, thanks for that. And I want to make it clear, I'm keeping an open mind on future legislation. I think we should put all ideas on the table, evaluate them, and see what makes the most sense, both for VA and ultimately the whistleblowers and the veterans that they're speaking out on behalf of. Maybe I could turn it to Mr. Wilbur. I just have a minute left, but I've introduced legislation that would increase independence for OAWP in part by creating a separate office of general counsel for the office. As an independent office, does the Inspector General have an independent general counsel?
Yes, the Office of Inspector General does have an independent counselor's office run by me as a counselor to the Inspector General. Yes, sir.
Okay. Any comments on the value of that or
Well, I think it's critically important to us as an independent organization. It's critically important that we have access to independent legal counsel. That was legislation that was passed a number of years back. Previously, OIGs were reliant on general counsel's office in the departments they oversaw, and that's just an inherent conflict, really. For us as an independent organization, we should be getting independent legal advice. And so, yes, I think it's critically important to have that.
Well, thanks for that response. My time is up. I'll turn things over to Ranking Member Mann for 5 minutes.
Right. Thank you, Chairman Pappas. I just have a couple more questions. Mr. Cordero, how would you respond to those that would say that many of the missions that the OAWP is charged with completing are duplicative of the work of other federal agencies?
So I think one of the critical pieces here is OAWP, the Office of Special Counsel, and the Office of Inspector General have unique statutory authorities. For example, the Office of Special Counsel typically would not investigate senior leader misconduct and poor performance. That would be investigated by OAWP. The Office of Inspector General, for example, doesn't investigate whistleblower retaliation. That would be investigated typically by OAWP or the Office of Special Counsel. So there are unique authorities. And again, we work very closely with these offices to ensure that when we have cases that overlap, we are trying to mitigate duplication of efforts. And I'll give you an example. The horrible events in Clarksburg, the Office of Inspector General issued a report on it. We work closely there to ensure that senior leaders are going to be held accountable, and we would investigate the allegations against the senior leaders to make a recommendation for accountability there.
Okay. The next panel of witnesses in their written testimony, they raised serious concerns about OAWP's investigations not being rigorous enough and stated often investigators don't interview relevant staff, including the accused, and go with their gut instead of the standard burden of proof for whistleblower cases. What would be your reaction to that?
So I think this office has substantially improved. A lot of those statements effectively pertain to issues and that occurred in that were referenced in the Inspector General's October 2019 report. Again, we have comprehensive standard operating procedures. These were tested by the Inspector General's office before they closed the recommendations. Our processes comport with standards used by other Inspector General offices, so we're in compliance and process the same way there. We have continuous professional education and training for our employees. These are actually these trainings occur with individuals who worked in DoD Inspector General's office, the Office of Special Counsel, so they are developed in a very comprehensive fashion. And then we have ongoing check processes internally to ensure that as investigations progress, that we're able to catch these deficiencies early in the investigative process to fix them, so we can work towards ensuring that we continue to work in a timely fashion for our cases.
Okay. Last question. When will the OAWP complete the review of the employees from Clarksburg?
We've started that review. I don't have a date offhand that I can give you, but we're working with the Inspector General's office to receive evidence. And so we're going to look at those evidence and then conduct the interviews necessary and perform the investigation necessary to make the recommendations. We can get back.
Would you have an approximate time frame, or if not an exact date, a desired month, or when would you anticipate that would?
I'd expect it in a few months, and I can get back to you with the time frame if that works later on. We've just recently received information about it, so.
Okay, we'll follow up with you on that and hope to get more specifics here moving forward. That's everything I have. Chairman Pappas, I yield back. Thank you.
Thank you. Chairman Takano, I'll recognize you for 5 minutes.
Thank you, Chairman Pappas. Help me understand some questions that, as a follow-up to what Mr. Mann asked, Mr. Cordero. Did I hear you right? Senior leadership is, by statute, is investigated by OAWP?
That's correct.
And as for retaliation, that's covered by OSP and the Inspector General?
No, for whistleblower retaliation, OAWP, individuals can file with OAWP or the Office of Special Counsel or both. And they often do file with both our offices.
Okay, so it's either one. It's either.
Right. Either or. You can do it. It's an and there.
Okay. And does either any of the other agencies other than the OAWP have the authority to investigate senior leader misconduct if OAWP does not?
I'm not sure. If could you restate that if you don't mind for me?
Well, my question is, if OAWP does not conduct investigations into senior leader misconduct, would either of the other agencies be able to do that?
The answer there is it depends. I think the Inspector General's office does look at certain senior leader misconduct, but not all the allegations may be looked at due to resources. So OAWP typically looks at every allegation independently, and we do take allegations of senior leader misconduct, even violations of VA policy, seriously, because there are overarching implications that it may have on veteran care.
Great. The question was asked of the OIG's counsel about the reliance the OAWP has on the Office of General Counsel. Do you view that as a problem, as a conflict?
So by law, we receive legal advice from the Office of General Counsel, but I want to emphasize our decisions and recommendations that we make in our investigations are our own. We take that very seriously, and we did that irrespective, effectively, of any advice that is provided to us by the Office of General Counsel. So again, we look at that advice as legal advice, but not binding on us in terms of making recommendations for disciplinary action and otherwise. And that's how we work with the Office of General Counsel.
Yeah, but my question is, should you have to rely on the Office of General Counsel?
So the short answer is the law requires us to do so. I think there is, again, with regard to legislation, I know there's a legislative proposal that's introduced that would establish an Office of General Counsel that would advise OAWP. Again, respectfully defer views on these bills in accordance with the department's position on it. So
you don't feel constrained to be frank with me here, but Mr. Wilbur, you see this reliance as a problem?
Again, the OIG also does not have a position officially on the bill. I can say that one can see potential for conflict in OGC, which represents management in its day-to-day function, also being asked to advise OAWP on discipline of that same management. There is at least an appearance for a potential conflict, if not an actual conflict, that might benefit from independent counsel. But again, I want to stress that the OIG has not taken an official position on the legislation.
All right, well, thank you. I'd like to explore, Mr. Cordero, OAWP's procedure for addressing whistleblower allegations about OAWP that are identified from within OAWP. There were press reports in 2019 about whistleblowers that disclosed retaliation from within OAWP itself. How is OAWP ensuring it has an office culture that does not accept this sort of behavior, this sort of retaliation? How are you ensuring that disclosures from within OAWP can be fairly and independently examined? How would that work?
So there are a couple of things here. Again, we have improved immensely our communication with our staff. We're a primarily virtual organization. We hold quarterly town halls, and we use the communication hub to have those discussions. We have an open door policy. I have an open door policy. I will say employees have a right to file complaints and to raise issues. We encourage them to do so. Because OAWP can't investigate itself, of course, we do encourage employees to file those complaints with the Office of Inspector General, the Office of Special Counsel, or if it's an EO complaint, the Office of Resolution Management, Diversity and Inclusion. And we respect those employees' rights to file those complaints and pursue those avenues of redress.
Mr. Chairman, thank you, Mr. Cordero. Mr. Chairman, I yield back.
Well, thank you, Chairman Takano. I have one quick one, if the committee members will indulge me for an additional minute or two. Mr. Cordero, I asked Mr. Wilbur about legislation that I've introduced that seeks to create some independence for OAWP, at least when it comes to the Office of General Counsel. Wondering if you could comment on how having a general counsel within OAWP would affect the office.
Again, I respectfully defer views on the bill on behalf of the department. What I will tell you again is we are by law, we receive legal advice from the Office of General Counsel. There are challenges that I think to Chris Wilbur's point that sometimes can arise. We work with the Office of General Counsel again, and when those challenges do arise, they provide us legal advice that we do not agree with. When it pertains to a recommendation or an investigation, we do not comport with it. If we believe that a whistleblower has been retaliated and we believe clear and convincing evidence cannot be overcome by the agency, we will find whistleblower retaliation irrespective of legal advice, because at the end of the day, in our independent evaluation through our investigations, we have found that burden has not been met by the department to overcome it. So that is the way we work when we do have those challenges. But again, by law, we do receive advice from the Office of General Counsel, and that's sort of the position that we take on it.
Well, thanks for that. And one loose end from before, I know several members have brought up settlement agreements, and I'm really not satisfied with that picture. And, that's why I think it's important that we reach out to GAO to make sure we can examine this issue and have the full picture about, how these settlement agreements are handled. And I think this is one area where we might need to see some legislative action. With that, I just want to turn to any other members who may have questions before we close out this panel. Well, seeing none, I want to thank our guests for your testimony today, for your patience with our questions, and we really look forward to working with you and wish you all the best in what you do for the people of this country and the veterans. So thank you very much. All right, well, we'll dismiss the first panel and we'll invite the second panel to turn their cameras on and show their faces. And in just a few seconds, we'll open things up.
Thank you.
Thanks, everyone. All right, well, it looks like we have everyone here. Welcome, folks. I want to introduce our second panel, and we'll start by recognizing Ms. Melissa Wasser. She's the policy counsel at the Project on Government Oversight, and I'd love to turn it over to you for 5 minutes.
Chairman Pappas, Ranking Member Mann, and members of the subcommittee, thank you for inviting me to testify today on whistleblower protections and procedures at the VA. Whistleblowers have played a key role in highlighting instances of waste, fraud, and abuse at the VA, yet they frequently face retaliation for their disclosures, while senior agency leaders face almost no accountability for their actions. Congress tried to handle the surge of VA whistleblowers by creating OAWP. This well-intentioned effort has several structural weaknesses that impede its functioning and independence. I'd like to focus today on the lack of independence between OAWP and the agency, OAWP's lack of enforcement power to implement discipline, the lack of meaningful reporting to Congress, and what Congress can do to fix these issues. One problem is the coordination between OAWP and the VA's General Counsel. After an investigation is completed, OAWP works directly with the agency General Counsel when drafting recommendations for corrective actions. Although OAWP and the General Counsel are both housed within the VA, their missions are not the same. The General Counsel's mandate is to represent the best interests of their client, the VA. Agency General Counsels often believe their job is to protect the public's perception of the department, future funding, and individual jobs of senior leaders. OAWP, on the other hand, is charged with fact-finding and analysis independent of any agenda to keep the agency out of legal trouble. Allowing agency attorneys to provide legal analysis or review is akin to a judge allowing a defense attorney in a criminal case to overturn the judge's decision against a defendant. It's entirely inappropriate for the General Counsel to weigh in on a whistleblower retaliation complaint or other allegations of senior leader misconduct. It puts whistleblowers at a severe disadvantage. I strongly urge Congress to mandate that OAWP have its own counsel. This is a reform Congress has made for inspectors general almost a decade ago and has resulted in better oversight. As Mr. Wilbur pointed out in the last panel, IG offices now rely on their own general counsel to provide independent and objective legal advice as they investigate claims against the agency. Having their own general counsel is absolutely critical for OAWP. And while OAWP has improved to some degree, more must be done to ensure accountability. Acting Assistant Secretary Cordero highlighted in his testimony that OAWP has directly investigated or referred almost 900 cases last year. However, the work of the office has not resulted in accountability. OAWP has only made 99 recommendations to address substantiated wrongdoing, and as mentioned in the last panel, the VA has only implemented approximately half. Currently, OAWP does not have the authority to enforce disciplinary recommendations or corrective actions. Because nearly half of these recommendations are not being implemented, the VA is sending a concerning message to its officials that they can act with impunity, especially when it involves senior leader misconduct or retaliation against whistleblowers. Congress should provide a referral option for OAWP to transfer a case to the Office of Special Counsel for disciplinary prosecution at the Merit Systems Protection Board if VA components do not implement the disciplinary recommendations or corrective actions. This would be in line with similar referral processes by IG offices and the Equal Employment Opportunity Commission. Finally, the current reporting system to Congress is not giving you the information that you need. It is not enough for Congress to get an unhelpful report regarding OAWP's recommended discipline, a notation and reason for why the recommendation was not implemented, and the offending official's job title. That means you, as members of Congress, have no idea if these events are happening in your districts to your constituents. For Congress to be able to conduct any meaningful oversight, these reports should also provide such relevant information as a summary of OAWP's findings, the name of the senior official who was found guilty of misconduct, where the official works, and if the official has a history of misconduct. While VA whistleblowers take the risk to blow the whistle because they believe it is their duty to speak up when they witness violations of this country's trust, the office meant to help them is failing them. Congress must fix this. POGO stands ready to work with the subcommittee to further explore how whistleblowers can be better protected at the VA. Thank you again for providing me the opportunity to testify today, and I look forward to your questions.
Well, thanks very much for your statement. Next, I'll recognize Mr. Tom Devine, Legal Director at the Government Accountability Project. Mr. Devine, you're recognized for 5 minutes. And you need to unmute, Tom.
Thank you. GAP currently represents 8 VA whistleblowers, and we're helping many others informally. 2 of our clients also testified at your 2019 hearings. Unfortunately, things have not gotten better. To illustrate, both of our clients who testified then, Dr. Catherine Mitchell and Jeff Detbrand, continue to twist in the legal wind while ongoing retaliation has them struggling for emotional survival. The same thing has happened with Brandon Coleman, the whistleblower who initiated the effective counseling and mentoring programs at OAWP that still have not been restored. The hearings did earn a bipartisan consensus that the status quo is unacceptable, and that's the first step. And interestingly, Mr. Cordero and his OAWP staff agreed with the dissatisfaction in more detailed briefings that they gave about how things are changing at the office when they talk to the stakeholders. Unfortunately, there's a credibility gap between that rhetoric and reality. Whistleblowers report that in practice, the agency operates without any published policies, is not bound by Whistleblower Protection Act legal burdens of proof, fails to communicate, routinely switches investigators without notice or explanation, canceled its effective mentoring program, and canceled its effective counseling program. Now, the case of Dr. James Murtaugh is illustrative. When he blew the whistle, he had been working for 5 years at a facility which recruited him and had given him consistently outstanding evaluations. His concerns: first, lowering a key indicator in mortality rates by withholding critical care to patients in the emergency room, convincing them not to have resuscitators so they'd be off the statistics. Second, denying specialty consultation to patients who needed immediate emergency care until the next day. And third, reducing mortality rates by shipping critically ill patients to other facilities rather than treat them, with consequences such as one patient dying on the hospital steps of the next facility. In response, the hospital stopped giving him assignments, refused to process his credential renewal, removed him, and apparently blacklisted him in light of the 25 applications that have been canceled after initial enthusiasm. Dr. Murtaugh only decided to make these disclosures after checking first with OAWP and receiving reassurances that he would be protected. Unfortunately, that's not what happened. After 3 years in a revolving cast of investigators replaced without notice or explanation, OAWP failed to interview his key witnesses, informed him that the OAWP operates from the gut rather than being bound by Whistleblower Protection Act legal burdens of proof, failed to address material evidence of blacklisting, accepted agency defenses at face value without giving him a chance to rebut, failed to tell him any additional evidence necessary to prove his case before ruling against him, provided no formal resolution and contradictory informal responses to his whistleblowing disclosure about the patient breakdown. And finally, contrary to OAWP's descriptions to us, refused to let him see the investigative file, requiring an FOIA that resulted in withholding significant portions. The pattern of internal retaliation against OAWP staff themselves helped to explain why it has been ineffective. Half of GAP's cases have involved OAWP whistleblowers facing retaliation. Under Mr. Cordero's leadership, there is serious negotiations to resolve 3 of them, but one that OAWP has refused to discuss is illustrative. It involved a highly decorated retired Army colonel who was in charge of investigations for all cases at OAWP east of the Mississippi. He was fired a week after alerting the OAW chief that, contrary to today's testimony, he would be cooperating with an OIG investigation into apparently misleading records about how to eliminate the backlog. The agency will not discuss the case. With respect to recommendations, there is no question that legislative leadership is necessary for both key problems, the lack of independent services and the failure to provide effective, legitimate investigations. We've offered 10 recommendations that are in more detail. I think the core, though, is the best of both bills. And the key is keeping OAWP's unique authority within the executive branch to provide temporary relief, but then following that with independent investigations and an option for due process. Remedial investigations, whether OSC or OAWP, can never be a substitute for a day in court. Thank you for the chance to provide this testimony.
Well, thank you, Mr. Devine, and we really appreciate your work and your being here today for this hearing. With that, I'd like to recognize our final witness, Ms. Jacqueline Garrick, founder at the Whistleblowers of America. I'll recognize you for 5 minutes.
Thank you, sir, and thank you for inviting Whistleblowers of America to testify on protecting whistleblowers and promoting accountability. Is VA making progress? A simple answer is no. There needs to be a much more aggressive effort to repair the tarnished institutional culture that veterans employees have uncovered at VA and the toxic tactics of retaliation used against them. We were optimistic that OAWP would be a place for employees to seek refuge from retaliation, find justice, and that grifters, racists, misogynists, and abusers would be held accountable. OAWP has gone through many reviews and has made some changes. However, overwhelming consensus from employees is that it is still too adversarial a process with little or no help. At your request, I reached out to more than 30 VA current and former employees about OAWP and shared their frustrations. Previous witnesses, Detbarn, Agavelli, and Mitchell, and the statement provided by Representative Boyle related to Christian Rule have provided status updates revealing little progress, ongoing retaliation, and no accountability. I added new information from such cases as Ted Blickwell's effort with Congress over vet center standards, but not as ongoing retaliation. Military sexual trauma cases found by the OIG in 2018 to be ineffectively handled are now going to be overseen by the same Tom Murphy leadership team that failed it in the first place. Then there is the colossal failure of accountability that Senator Grassley has raised regarding insider training and Charmaine and Barrett Bowe conflicts of interest and the proposed but not executed suspension of Tom Murphy, who was transferred but is now the acting USB. Senator Grassley has opened an investigation into ethical violations and leaks of sensitive information, but VA has failed to respond. Why? According to OAWP, it investigates misconduct, poor performance, and retaliation. However, employees have shared emails that it cannot investigate discrimination, hostile work environments, reprisal, or allegations already covered under another administrative process. And if you want information, you must file a FOIA. This contradicts what we've heard today. Yet VA does not process FOIAs or delays responses, changes dates, or adds multiple tracking numbers. It is subverting and denying justice by withholding necessary evidence, resulting in a FOIA lawsuit. OAWP briefed it implemented OIG recommendations and has taken comparative discipline actions as OSC, which means that there was a greater need for discipline in the VA than the rest of the federal government. It published a directive, which is available, but an SOP, you need a FOIA, which is not always forthcoming. And why should VA employees have to follow a directive they can't see? OAWP recommendations, as discussed, are non-binding, so there's no forcing function, even though they advise the secretary who could make binding decisions. Why not go directly to the secretary for mandated discipline or refer to OSC? Ethics reporting and review violations should be among OAWP audits. It could enforce better accountability and penalty, and if it did, NASCAR situations might have been avoided. Ethics violations have been so pervasive, the need for more training has been the excuse for not sanctioning senior leaders who should otherwise be held accountable and penalized for accepting gifts. VA officials have had to step down, but the door is open for their return. OAWP should track these officials, and those reports should be made public. The revolving door must close. OAWP has supported the option of allowing VA employees to request a jury trial, and employees who go to OAB seeking help should have a statutory duty to assist any employee who files a complaint with independence from general counsel and fair representation to equal to the defense it provides VA officials. A duty to assist under Title 38 and 38 CFR are not unique. OAWP should explain and obtain evidence necessary to substantiate claims, assist in documentation retaliation using an OSHA standard, offering options for remedies, independent mentoring, training and peer support, and use a SAMHSA trauma-informed model, recommending damages caused by retaliation. There is a growing body of evidence that whistleblower retaliation is a moral injury and can cause PTSD, depression, and suicidal ideation. Enforce the Dr. Chris Kirkpatrick Two Strikes Act, like in Poplar Bluff, and employee suicides. We are grateful for this opportunity to speak out today on behalf of employees, and I conclude by thanking you again for giving us this opportunity and to recognize the heroic actions of VA employees.
Well, thank you very much to all of our witnesses for your opening comments, and we'll now turn to some questions here. I don't know if you heard what transpired on the last panel, but I thought it was an important conversation. One of the things that Mr. Cordero said during the first panel was that OAWP has improved its investigations procedures and whistleblowers are getting timely and complete investigations from OAWP. And I wanted to get each of your reactions to that. In your experience working with and representing whistleblowers from VA, is this true? And maybe I could start first with Ms. Wasser.
Sure, thank you, Congressman, for the question. I did get to hear the comments made by Acting Assistant Secretary Cordero. While there have been steps to get more accountability out of this office and they've improved slightly, there's still so much more work to be done here. I think as we heard from Mr. Wilbur on the last panel talking about the independence of the IG and having their own general counsel, I'd really highlight for this committee that OAWP would be significantly strengthened if they had their own general counsel. Even relying on they need to statutorily rely on the agency general counsel to provide legal advice, gives an improper appearance of a conflict. And I really don't think that that office can continue to, or even be independent without their own general counsel.
Mr. Devine, can I ask you next? Oh, Mr. Devine, we're getting a little bit of feedback from your connection. I don't know if you changed something with your internet connection at all. Maybe try it one more time.
Yes, sir.
Oh, it looks like the audio is a little bit garbled on your end. Maybe I'll turn to Ms. Garrick first, and we'll see if that evens itself out.
Yes, thank you for the question. So would you want to wait 240 days for a resolution to feel whole? When I talk about the depression and the suicide and the PTSD that people are going through, that's every day of their lives. And I think we have to really think about how that relates to some of the suicide rates that we see in this country and the VA's own prevents program that says the workplace should be considered as one of those areas where harm can be done. And I go back to the Chris Kirkpatrick Act. Why aren't we not reporting those suicides? We've, in testimony, have shared how suicidal people feel when they go through this. So if 240 days is what it takes, then I would say no, we're not being timely. We're not being accurate. Imagine if a veteran had to wait 240 days to get care. This committee would be outraged. I think we should share that same outrage over employees.
Well, thanks for that. Would you say that progress has been made, Ms. Garrick, over the last couple years? Certainly not in terms of the individual that you mentioned and how long they've waited for a resolution, but what about in other aspects of OAWP's work?
Well, so I'm grateful for the briefings and the conversations that Dr. Bonzanto had at the end of her tenure, and Mr. Cordero has been meeting with us, and I do believe there's an honest effort here, but I think it's impaired by not having independence from general counsel, by there not being these kick-out abilities, and by the organization not having a duty to assist develop a claim. If we looked at how we treat veterans, the organization must provide. And this, we've been talking about standard of evidence. What does clear and convincing mean? What does preponderance mean? What does reasonable doubt mean? Most employees don't know what that means. So when I say there should be a duty to assist in understanding the evidence and an ability to seek damages for PTSD like you do for personal trauma. If somebody in the military has been bullied, harassed, hazed, they have a right to request service connection. Why shouldn't employees have the same rights? So I look at some of these things and I would really, truly encourage that we have a broader perspective in how we meet these needs.
Sure. Mr. Devine, maybe we can try your audio one more time. Oh, it still sounds a little bit unintelligible, unfortunately. So maybe we'll work on that connection there just for a second. I apologize about that. I'm wondering, in just the few seconds I have left, Ms. Wasser, I'll turn it back to you. If you could talk about the most important change that OAWP needs to make to be a more effective and trustworthy office. You alluded to a few elements there, but what should be the top priority here?
Thank you for the question, Chair Pappas. It would be really hard for me to pick one top reform. I think pursuing one top reform would be doing a serious disservice to our veterans. What I think this subcommittee should focus on in combining these two bills is obviously the lack of OAWP specific general counsel, along with the lack of enforcement power OAWP has. The office has done a lot of the hard work over the past few years with good intentions, like Ms. Garrick has pointed out, but even when they substantiate allegations, they're still not holding people accountable for their actions. And so that lack of enforcement is really hampering the agency. So focusing on both of those elements should be the top priorities for this subcommittee.
Well, thank you for that. I'm over on my time. I think we'll get into a little bit more of that. And Mr. Devine is probably trying to reconnect here. So hopefully we'll hear from him in a minute. With that, Ranking Member Mann, I'll turn it to you.
Yeah, thanks, Chairman. Thanks all three of you, our panelists, for putting the time and effort and doing this here this morning. My first question is for you, Ms. Garrett. Is it your experience that the range of proposed discipline that comes with OAWP's recommendations almost make it harder for VA managers to rely on these recommendations for action?
I don't know if it should make it harder for the range of disciplinary actions. I think that when discipline is proposed, there should be a serious concerted effort to have it enacted. And as I think you mentioned earlier, either it's flawed, either the recommendations are flawed, or they're being ignored. And if the OAWP answers to the secretary, then where is the power of the secretary behind OAWP to enforce discipline? And that would be my question. And why aren't they, I mean, why isn't the VA able to police itself? Why do we need Senator Grassley and the SEC to look into issues of insider trading while these issues were known to the VA? I know I raised them in 2019, and I raised them with Ms. Bonsanto. So where is the ability to take action?
Yeah, and maybe another question, how does OAWP's reputation within the department impact managers' decisions on whether to take actions on the recommendations?
Well, I think that goes back to what everybody's been saying about this lack of trust. If they're not independent and they don't have counsel equal to what whistleblowers don't have counsel equal to what VA officials have. I mean, think about the cost to this. Whistleblowers are out of pocket. Thousands and thousands of dollars get spent by the whistleblower. In the meantime, the SES, who has a lot more money at their disposal, are the ones the VA or the government is defending. So there's a real imbalance of power here.
Yeah, no, that's right. Do we have Mr. Devine back? I saw him briefly, and then maybe he signed off again. Then another question maybe for you, Ms. Garrett. Can you expand on your written statement about the differing experiences that Dr. Ogilvie had with AOWP and with OSC when investigating their claim?
Sure, and I appreciate Minu's faith that I can speak for her, and I will do my best here, but I would certainly encourage you to reach out to her directly. Okay. Her experience sounded like there was a lot of discrepancy, first in what OAWP was telling her. They don't share their SOP, so how do you know what you're agreeing to? I mean, she raised that issue, I think, rather clearly. So you have to FOIA the SOP, but you're supposed to sign that you agree to following these procedures, but you don't know what they are. She is still on this detail, not in her job. She's a psychologist with a specialization in addiction. Why isn't she working and taking care of veterans? Why is she still, she called them made up nonsensical jobs when she could be doing a job that is what we're all here for, is to help veterans.
Yeah, no, I agree. Well, thank you all. That's all my questions, Chairman Pappas. Thank you all very much.
Well, thanks. Ms. Luria, you're recognized for 5 minutes.
Well, thank you, Mr. Chairman and Ranking Member Mann, and thanks to our panelists for joining us today. One of the questions that I wanted to dig into further is, what can Congress do to ensure that whistleblowers are protected? You've mentioned that there are conflicts of interest in the OAWP, not to mention whistleblowers who don't trust the office. And I recognize the office has made progress and improved since its founding, but what more can be done to get the office to where it needs to be? And I would love to hear from each of you. So Mrs. Garrett.
Sure. So again, I come back to this notion of a duty to assist. The developing the evidence, the responding to FOIA, why we even need to FOIA. I know in my own personal experience, when I sent a FOIA to the DoD, I got a trove of information that I was able to read to the MSPB judge that helped to make a decision in my case. VA employees are being denied that same equal access to justice when their FOIAs are 2 years late. They're broken down into these multiple tracking numbers. It makes it harder to adjudicate the case. So better responsiveness to FOIA, a duty to assist, independence from OGC, and fair and equal access to justice with counsel representing them, not just the VA.
Well, thank you.
Thank you for the question, Congresswoman. I would say, just to echo my prior statements, that lack of enforcement power and the lack of OAWP General Counsel are really the two largest. I think I would also point out with the ability to fix some of the enforcement issues, the Strengthening VA Whistleblower Protection Act of 2021 would establish an OAWP specific general counsel, but we at POGO think it could be significantly strengthened by providing a referral option for OAWP to transfer a case to the Office of Special Counsel for disciplinary prosecution if VA components do not implement that recommendation. I know Ms. McMurray from OSC mentioned similar referral processes in the first panel, and we believe that would be way more effective in terms of getting these disciplinary recommendations implemented. For Congress specifically, though, I really think reporting transparency is of the utmost importance as well. The current reports being sent by the VA to Congress do not give you enough information to even tell you where the events are happening. It might tell you it's a physician at a VA center, but it's not going to tell you location, if that person has a history of misconduct. And so strengthening those reporting requirements, I believe, could marry the two bills that are currently on the table.
Okay, well, thank you both for your recommendations. And I'm not sure if Mr. Devine's audio is back.
Looks like he's trying to connect, so maybe he will pop on. Tom, are you there, Mr. Devine?
Okay, well, it seems that maybe there's an ongoing technical difficulty. So if Mr. Devine, you do have additional information, we'd love if you could pass that on to us after the hearing. And I wanted to say thank you to all of our witnesses for being here today, and I'll yield back the remainder of my time.
Well, terrific. We'll just give him another second to see if he connects. I think he's working with committee staff to find an audio link that's going to work.
We'll just go ahead and hope. Yeah, let's go ahead with the questions.
Okay. Well, why don't we go back to our other two witnesses? I appreciate your time, and we'll just give it another couple minutes to see if Mr. Devine comes back. You heard some of the comments on from our last panel. I appreciate that you're coming with some concrete recommendations. I think that's really helpful for how we move forward. And Ms. Wasser, I really liked your comments about additional detail in the reports to Congress that can help us get the clear picture of what's going on and what these individual cases look like and what people are experiencing. Is that something that we can work together on moving forward?
Absolutely, Chairman Pappas. POGO stands ready to help you and the subcommittee figure out the technical language for that fix.
Well, that's terrific. Well, great. And Ms. Garrick, I don't think I got to you last time when I was asking Ms. Wasser about sort of the top reform. I know she mentioned a few. You've given us some suggestions. If you could distill it in terms of where we need to go, what would be your roadmap for this committee?
So yes, well, so I'm very impressed with how articulate Ms. Wasser was in her recommendations. So do all of that. And I would, again, ask you to look at how does the organization help the whistleblower develop their claim? I can tell you, coming from this as a whistleblower myself, that this was hard. It was a hard road to learn, and having the mentorship program, having the peer support one of the reasons we created Whistleblowers of America in the first place was because we needed each other to help figure out what some of these things mean. So I would really encourage you to look at the accountability, the duty to assist, the independence from the OGC, and being able to address these FOIA issues, and to work with Senator Grassley's staff on what they're doing with this insider trading issue and some of these revolving door and lack of accountability issues.
Well, thank you for that. I do see Mr. Devine on camera. Do we have audio for you too, sir? We are not hearing your audio right now. I'm not sure if you called in from a phone line, but we've got a 240 number that's connected. And it looks like the audio just needs to be unmuted on that phone line. It's not connecting. Okay. All right. Well, Mr. Devine, if you can hear me, we will take your any additional comments that you had about the questions that were posed to the other members of the panel for the record. And we'll follow up with the members of our subcommittee and see if they had anything additional that we might be able to communicate, to you in writing. So, Representative Floria, did you have any other questions before we close?
Well, Chairman Pappas, no, the witnesses have been very informative and I don't have any further questions, so thank you.
Okay. Well, thank you. And I want to thank the members of our panel for joining us here. I apologize for the technical difficulties. I do hope very soon we will be back in person. This is an issue that we are not giving up on or walking away from. And I think, the legislative drafts that are out there are just the beginning of the conversation of some of the remedies, that will be considered as we move forward. And I think your comments have been very helpful and instructive to us in understanding what makes sense, what our whistleblowers are experiencing, and how we can best make sure that they are protected moving forward. So I know the subcommittee has a lot of work in front of us, and we do hope we can find a bipartisan consensus on this legislation, and we will work in that direction. So thank you to all of our witnesses for all of your contributions, for your advocacy, and for your presence here today. And with that, members will have 5 legislative days to revise and extend any remarks and include any extraneous material. The hearing's now adjourned.